Good afternoon and welcome to our web conference regarding remote working and data protection. I am Delphine Monnier, in charge of Labour and Employment Department in Cornet-Vincent Ségurel in Lyon office. And I'm very happy to present you this web conference with my colleague, Pauline Ducoin.
Hi everyone, I'm Pauline Ducoin. I'm in charge of the innovations part here also in Lyon. We are very happy to talk to you about remote control and the data protection and IT security aspects of the remote control. If you have any questions during the presentation or any concerns, do not hesitate to use the chat and the question section on the right side of your screen.
Well, let's start the presentation. We will go through the definition and legal framework of remote working in France very quickly, and then we will have some feedback after the implementation of remote working during the first lockdown in France and the ambition of the national interprofessional agreements of November 26, 2020 on remote working.
And we will also talk about the aspects that were forgotten for some time, which are data protection, IT securities, and we will give you our feedback from the regular questions we have from clients about how to implement remote working, and what kind of difficulties they are facing.
So, the definition and the framework of the remote working is quite simple. The definition has been introduced in the Labour Code in 2012 and is quite wide, as you can see in this slide. Let's have some little bit of historical background now regarding the definition and the appropriate legislation regarding the remote working. As you can see, remote working is a very international topic because in France, the first company who has implemented experimental company agreement was IBM in the 90s. So obviously it's a US company. Then we have some European directive who has implemented a framework of the remote working and which have been transposed into French law in France as from 2005 by the National Interprofessional Agreement. A few words regarding National Interprofessional Agreement. We love this kind of agreement in France. It's when unions of employers and employees very widely in France reach an agreement, signed it, and then it's ratified and extended by an act, specific act, and then it's enforceable for everyone. And lately, on the 26th of November 2020, a national interprofessional agreement has been signed to give some simplicity to the employers, because all these texts that you have on that slide are cumulatively applicable and no text supersedes the other. This is why the ambition of this text is to facilitate the recourse of the remote working.
On the data protection aspects, everyone knows that in 2018, GDPR came into effect, and it was a big deal. It is still a big deal, but in fact, in France, Data Protection Act exists since 1978, and the real new challenges about the COVID crisis regarding GDPR aspects and IT security are actually the new kind of data that employers are facing processing, such as sensitive data, health data, COVID-related data, and also the IT aspects and the breach of securities that everyone had in experience since the first lockdown in France, which was pretty much at the same time in all over the world last March.
There is different forms of remote working, and as per employment law, it's very important to identify them, because the duty of the employer as regards the expenses and the occupancy allowance due to the employee are not the same. So when we have an alternate remote working, which is an executed part-time remote working, which is quite the most popular form of remote working, 1 to 3 days per week remote and the rest on face-to-face, you don't necessarily have to pay an occupancy allowance to your employee. And you will probably negotiate in your charts or in your agreements the coverage of the expenses incurred by the remote working. But it's a really negotiation point. Then you have the home office. In this form of remote working, we consider that the remote working is executed on a full-time basis at the employer's request when the company does not have premises in France, for instance. In this case, we have absolutely the duty to pay your employee an occupancy allowance each month. But we have also the case when the home office is a request from your employee. And in this situation, when the employer has premises and the employee by convenience wants 100% remote working, you will not have to pay an occupancy allowance to your employees. So it's quite subtle, but I think it's important to underline this fact at this stage. Then you have the exceptional remote working that we have all experienced during the lockdown. And it's the only form of remote working where you can impose, the employer can impose remote working to all its employees. And in this situation, the reimbursement of the costs incurred is also quite complex, but we will see that later on. Then the last form of remote working is the satellite office, where the remote working is exercised in company-owned premises or co-working spaces paid by the employer. So in this case, again, the occupancy allowance is already paid in a way by the employer by paying co-working spaces or satellite premises, and the employee will only have the costs incurred by remote working, but again, it's a negotiation point, not an obligation.
And those different forms of remote working also ask about the data protection and especially the security, the IT security aspects, because obviously when you have a home office or a satellite office, usually the employer made it available to its employees professional devices specifically for the professional area of expertise. So this is not new, and this is something that was already implemented before the crisis. But when talking about alternate remote working or exceptional remote working, for example, relating to sanitary crisis, then the devices were not available for all employees. And so it asks a lot of different questions about how to secure a way of working from home for people that don't usually work from home or not all the time work from home. And on the GDPR aspect, how to collect and process data from home and, for example, from personal devices, which can lead to security breaches, as you may remember this summer or even in late October, some big firms were subject to security breaches partly because of the fact that some workers that are not usually at home were working from home and were remote working from personal devices with lower security policies.
The main legal principles of remote working are both on labor law aspects and also IT and data protection aspects. The voluntary basis for both employer and employee is really important, as well as the reversibility. The reversibility is very important because some employers have found in the remote working an opportunity to reduce the spaces of their premises and use flex offices, which can be a difficulty as regards with the reversibility of the remote working, because when your employees will ask you to come back to your premises and that you will not be able to give access to all of them to offices, then you have a problem regarding this principle. So this is very important to bear in mind, this reversibility. In another way, when you are an employer, you can have the wish that your employee all come back to work when the workplace is COVID-19 safe. It would probably be the case, hopefully, after the vaccination campaign, which is ongoing. So this reversibility principle is quite important, and I think it's very important to bear it in mind when you will have to draw your own charters on remote working. The other principle, which is not really well adapted, but still is there, is same rights and obligations for workers, whether you are a remote worker or a face-to-face worker, which means that in terms of lunch vouchers or public transportation pass, some institution like Labor Ministry or yourself considers that based on this principle, even though your employee is working remotely, you still have to provide him with lunch vouchers and also public transportation pass reimbursement, which is a complete nonsense. So it's quite complex again to articulate this principle with the situation we are facing, but it is very important to anticipate all the issues that may be created with the application of this principle in labor law.
Again, the same kind of principles also applied in the IT and data protection aspects. You're supposed to apply to have the same ruling going on, whether for employees' presence in facilities, in the employer's facilities, or if the employees are working from home, which is quite difficult also from a security point of view, because even though you're not looking at what employees are doing all day long, even when they are on the facilities, it's even more complicated to check whether or not they are working safely, if they are working with the right devices, if anyone else at home is using the professional device or not. And so even though the same applicable principles to processing and to security apply for remote workers, it's complicated, and you have to adapt a lot of your company policies to be well adjusted and to be verified in a home situation office.
And to reply to Pauline, distance, social distancing, and remote working does not erase the employer and employee relationship, especially regarding the monitoring of the employee's activity and the monitoring of the working time and the right to disconnect as well. So we will see at the end of this presentation the practical feedback and the popular question that we have on this subject, which is very the link between our two expertise. But this is very, very important. The implementation of remote working, just a quick reminder, we can implement remote working by a collective agreement, or in the absence of a collective agreement, by a charter drawn up by the employer after consulting the social and economic committee. And in very small companies where you don't have unions, where you don't have social and economic committees because you have less than 11 employees, or because just you have no candidates, then you can propose directly an agreement between employee and employer, and it can be formalized by any means, which means that it's not necessarily an agreement an amendment to the employment contract, even though I encourage you to reach such agreements, but we can just write an email to have this agreement between employer and employee. The specific provisions that this kind of agreement must include regards the conditions of transition to remote working and the condition of return to an execution of the work contract without remote working, which is the expression of the reversibility principle, the terms of acceptance by the employee of the conditions of implementation of remote working, the procedures for remote monitoring working time, which is very, very touchy, if I may say, and the time slots during which the employer usually contacts the employee working remotely, which is very important on the efficiency of the right to disconnect, and as well all the claims that an employer can have regarding overtime.
Just to keep in mind the GDPR principles, we need to remind you, even though I know it's not very exciting to talk about main GDPR principles, but just to keep in mind that GDPR still applies in a remote working situation. And basically, for me, there are three main problems, and the things that are not considered by some companies is that you need to have a law basis, a legal basis to process personal data. So keep that in mind. You also have the data minimization principle, meaning that you're not supposed to use or to process any data that is not for a specific purpose. And this is very important because the tendency during the sanitary crisis is to monitor everything. Usually you don't ask an employee that is coming to his office whether or not his vaccination are up to date, or if it took its temperature the morning, or anything like that. So the tendency is during a sanitary crisis to ask those kind of questions, or to be tempted to put into place some new policies around health. So you always have to bear in mind the proportionality purpose that GDPR instaured. And also what I was already talking about, security aspects, because you have the security aspects from a device perspective, meaning whether or not you have laptops, professional laptops, personal laptops, but you also have the security obligation regarding GDPR principles, meaning that you are supposed to ensure the security of the data collected and processed by your own company, but also for other companies, for your clients, for your employees, for any third party. And so these are some principles that need to be taken into consideration even in a remote working situation. And even though I understand that this was not the priority, but it led to some complications such as security breaches and some ransomware at some point. But we will talk about that later again.
Let's talk now about remote working during the lockdown due to the pandemic crisis. Clearly, working remotely is a very strategic point, and at this point in France, we are the maybe only country with no lockdown, and because we have a very strong recommendation from the French government to implement remote working. And I have a very, very hot news to announce here, because yesterday the Labor Inspectorate, which is called in France Direction Générale du Travail, has released an instruction to all the Labor Inspectorate to ask them to control every company to make sure that when the duties can be working remotely, the remote working is implemented, which means that in specific engineering companies or law firms, for instance, or accountancy firms, we can have labor inspectorates coming in our premises just to check if everybody there cannot work remotely. And if it's not the case, maybe they will take some sanctions. In my point of view, this instruction is not really a law. The National Health Protocol is not an enforceable law as well, but still, we have this instruction, which is very important to have in mind. And we have some inconsistent message because a few days ago, the Labour Ministry told that the 100% of the time worked remotely must be eased off with 1 day per week worked in the company premises. So we can see that the remote working is coming back as a very strategic topic in HR and in more generally the counterpart of potential new lockdown in France. So here is the text of the French Labour Code, which enables the employer to force its employees to work remotely. And in the slides just after that, I remind you the guidelines that was provided by the Ministry of Labour to implement the remote working for managers, for employers, and for employees, which are quite good sense principles that I will not detail that, but I think it might be interesting for you to have these principles reminded here.
Also, last but not least, the CNIL said something because, as Delphine was reminded you, the Ministry of Labour was very active, proactive on the topic of lockdown and remote working, because it was the first and the main concern for every company in France and worldwide. The CNIL, as most of the companies, did not take the topic at first because it was not the main concern. And so we had to wait until last November for the CNIL. So the CNIL is the French authority in charge of data protection in France. So the CNIL provided us with some Q&A last November saying, well, you know that GDPR still applies even though we are in a sanitary crisis. And so you have to keep in mind that you're supposed to implement new stuff, but you have to use the proportionality principle between the purpose of data processing and respect of the rights and freedoms of employees, for example. And this is one of the main topics that we will be talking about, is the activity monitoring. Because the employers, and this is quite understandable, wished to implement some way to monitor their employees at home. They did not really think about the consequences from a GDPR or even a psychological point of view. And so the CNIL pointed out the fact that you cannot do whatever you want or whatever you think of just because we are in a sanitary crisis and that people are working from home. And so the CNIL also said that we have to keep security and confidentiality of personal data at a maximum, or at least as usual. And for example, you cannot impose to employees working remotely to have their camera on when participating in a video conference or a meeting, even internal meetings, you cannot impose that to your employees. But we will talk again about that later. And so the CNIL provided some recommendations for the employers and for the employees, especially concerning the security of the data process from the employee working from home. For example, the CNIL advised to provide teleworkers with VPN, with firewalls, with antivirus and encryption method, because obviously when you have that in the professional facilities, you obviously or rarely have that at home. And as the sanitary crisis came in a hurry, everyone was not equipped, and every employer was not in the capacity to provide their employees with professional devices. And so they had to do something with what they had at the time. And so they had to adapt during the first lockdown, but we still have to adapt, and all companies have to adapt to remote working, as it will be more expanded after the crisis, even though some and most of the employees will come back. Some of them will still be in remote working basis. And so everyone has to adapt its own policies and the equipment relating to remote working.
So now the topicality of the remote working in France is this interprofessional national agreement, INA, signed on the 26th of November 2020. Clearly, the ambition of this INA is to give and provide a clear framework to all employers to implement remote working in the company, but also maybe to give the ambition to the employee to really adapt the rules in their own company to define a sustainable way to remote working in the company. Few facts. In 2017, only 3% of remote workers on an usual basis in France. During the lockdown, over 25 of remote workers in France, compared as all the workforce in France. So this is why at the end of this first lockdown, unions of employers and employees started a joint diagnosis in order to provide a guidance to companies regarding remote working. The conclusions of the joint diagnosis prior to the negotiation in itself of the INA was the issues of social cohesion at the national level and in companies. We all stated that the lockdown and remote working emphasizes the digital fractures between employees as regards to the level of mastery of tools, as regards of the level of comfort in the home, and also regarding the professional category, because 58% of managers have remote worked compared to 20% of employees and 2% of workers. So clearly managers were much more protected than employees and workers. So this is a very important point. The only thing which was pointed out was the distancing of social relationships and the psychological risks incurred with that. They also stated that there is challenge in adapting work organization, and especially regarding managerial practices and securing data exchanges at distance. And finally, the unions of employers and employees have very well in mind that remote working is clearly an attractive thing for employees and a retention of employees now. And clearly, all companies have really a big interest to draw up their own charter and a sustainable way to remote work. Finally, before this INA negotiation, it's quite interesting to know that they consulted the National Agency for the Improvement of Working Conditions, which is the ANACT in France. And in this chart, you have the summarize of the pros and cons of the remote working. Clearly, the balance is quite good because there is as much advantages as much disadvantages, but the ambition of the INA was to provide a guidance again to the employers and companies to find their own balance regarding their business, regarding their own work rhythm, to find the better way to implement remote working. In this slide, I have summarized the sticking points in the negotiation because, as you may know, the negotiation was quite long. The duration of the negotiation was 2 months, and there was a very strong position on the employer side and on the employee side. On the employer side, it was very clear that they didn't want a text prescriptive nor normative. And the less that we can see is that they achieve their goal on that matter, because the INA is just a framework which is not directly enforceable in companies. On the other hand, the unions wanted that this text became a very strong and normative text. But on this side, they clearly lost the negotiation. But the union employees have won a point. It's the maintenance of the presumption of imputability for work-related accidents occurred during working time. Indeed, when an employee has an accident in his home because he's working remotely, it is still considered as a work-related accident, which is very difficult for an employer to accept because he will have to pay additional contributions because of that, and he has obviously no control on the home of its employees. So this principle was very much challenged by the employer, but has been maintained by this INA agreements. Then there was discussion around the eligibility of remote working position because the employees wanted that the employer cannot decide within an employee category whether such employee can be eligible and such other one cannot. And the employer unions succeeded to maintain the right for the employer to choose who is eligible or not, which is a very good news because it means that within the same department, the employer is still able to determine whether an employee with experience, which is autonomous enough, can have the remote working compared to a newly hired employee or a new employee who has just get his diploma, to not to have remote working without having discrimination claims against it. So these sticking points were really interesting. And finally, the inputs of this INA are quite interesting, even though, again, they are not directly enforceable against companies. The points on which I want to insist now is the coverage of professional expenses. Clearly, the unions of employer and employees have decided to not really draw a clear rule on this subject, and wants that every company chooses its own rules on this subject. But what is interesting is that this INA refers to the URSAF decision, which considers that you can totally decide to allocate to your employee daily allowance on a pro rata basis to cover expenses of the remote working without having to pay social security contribution. So the URSAF told that if your employee is working 1 day per month remotely, then you can give him 10 euros per month, and this allowance will not be subject to social security contribution. If it's 2 days per month, it will be 20 euro, 3 days per month, 30 euros, and so on. So it can be interesting to for employee to comply with this proposition of reimbursements of professional expense. Finally, the National Health Protocol, which is updated very regularly, has lately been updated on 19th January and provides that the INA of the 26th November 2020 is very useful and gives a direct reference to this text to implement the remote working. At that time, the National Health Protocol told that the use of audio or video conference meetings could be relaxed with occasional face-to-face meeting, and also the return at work of 1 day per week of remote worker. But let's see what will be the next version of the National Health Protocol.
And as Delphine was pointed out, the main and the principles still maintain in remote working environments, meaning that the responsibility of the employer is still the same regarding its employees, which can be weird at some point, but it is still going on. And so, for example, as we already talked about, the problem of sensitive data applied to the remote working or even the facilities working employees, because on one side you have the responsibility of the employer for the security of its employees, and on the other side you're not supposed to do whatever you want and to collect sensitive data when it's not necessary. So, for example, after the end of the first lockdown in France, which was middle May of last year, some companies felt the need to implement new policies for working for employees coming back to work in the employer's facility. For example, and I remember that we heard about that over the news, some companies thought about implementing mandatory temperature readings or medical questionnaires prior to coming back to employer's facility. At first, some companies thought that it was a good idea to have like a temperature device at the door, and so each and every one employee coming in would have to check its temperature. Then the employers thought that they might have to hire someone just dedicated to take temperature for employees. So they decided, well, we have to implement something maybe less weird. And so we will trust our employees to testify that each morning, prior to coming to the employer's facility, they will take their own temperature and testify that they are under 38 degrees. Well, this is not admissible from a GDPR point of view, because you cannot discriminate people based on some sensitive data that are not purposely processed. Meaning, if it was a requirement prior to the sanitary crisis, for example, if you are working in a very dangerous chemical industry, I don't know, and that since the beginning of time, you had to take your temperature before accessing the facilities, well, you're okay because nothing changed there. But if you are, for example, a law firm or a consultancy firm, and nobody never asked you to take your temperature before coming to work, then the employer is not supposed to ask for that during the sanitary crisis or after the sanitary crisis. So we understand that we all have some fears, but we have to keep in mind that the main legal principles, whether on a labor law aspect or on a GDPR aspect, must be followed, even though this is a very specific situation and period. And so the CNIL, so still the French authority, advised to make sure that all the employees are aware of what they are supposed to do or not do, what they are allowed to do, whether at home or in the employer's facility. Make sure that you provide all employees the policies and the guidelines on what they should do if they, for example, are contact cases for COVID-19, or if they are infected. And so to be sure that they know that, for example, they're not supposed to come to the employer's facility if they have a positive test. But you're not supposed to be the employee instead of the employee as an employer. And you're not supposed to collect more personal data, especially sensitive data, more than needed, even in a sanitary crisis.
We will probably face in the really next future very accurate and issues regarding the vaccination in the workplace as regards with the sensitive data, because on the one hand, we ask to the employer to provide a safe workplace, and on the other hand, the vaccination is not mandatory in France. You have the liberty and the right to refuse to be vaccinated. And what will be the policy that an employer can really decide in this situation? I am sure that my clients will ask me in the next future, well, Delphine, can I refuse the access in my premises to employees who refuses the vaccination? And in this case, can I impose them to continue the remote working, even though I am not satisfied with this way of work? It will be very complex to answer this question, and probably the only way to resolve that point will be to very well anticipate this question and to really accept the fact that remote working will be the response for the next few years, maybe. So really, I encourage each company to anticipate and think about the reversibility principle and a sustainable way to have a satisfactory remote working in the company. So now we will go through, unless you have some questions at that stage, we will go through the practical questions and feedback that we have regarding remote working. Does the employer have an obligation to respond favorably to a remote working request? No. In normal circumstances, because of the double volunteering principle. The employee cannot impose to its employer to work remotely. But now, in our in the current health crisis, it is clear that the question is different if the employee has a fragile health condition or if in its direct family he has a fragile health condition person, its wife or husband, and probably the remote working can be imposed to the employer. But again, it's a question of common sense rather than a question of employment law. Because as you will see in this slide and the following, I will constantly refer to the National Health Protocol, but bear in mind that this has no legal value. It's just guidelines given to the companies and employers to have a safe workplace. And as it's the only guidelines that we have, clearly to preserve the company from claims regarding COVID infection and all liability of the employer, we have to comply with this national health protocol. Can the employer impose remote working on his employee? Yes, in case of exceptional circumstances only, but no in absence of exceptional circumstances. How to determine the remote workable positions in the company? The Labour Ministry, in its Q&A on remote working, gives some guidance. So step 1, list the main activities for each job position. Step 2, for each of these activities, evaluate the possible obstacles of difficulties to remote working for the company, the clients, and the remote worker. For example, the remote server access, the quality of the internet network, the data confidentiality. And step 3, identify if means and conditions can be made to overcome these difficulties. Again, it's common sense, but it's not that simple. What about the trainees in the company? What about jobs that incurs to be exercised alongside with a manager who shows the employee how to do some of the duties? The Labour Ministry does not respond to all of these questions. In my opinion, trainee and apprentice probably are not eligible to remote working, but in the real life, what we see is that the schools and university refuses to suspend the training program because of the lockdown. So we have to face to a very rare situation where by the employer is facing a situation where the remote working is imposed to him with employees who are clearly not eligible to that. So it's a quite complex situation. And again, the best person who can answer to this question is the company itself and its staff representative or its employees and employer directly.
And as Delphine was saying, the case of trainees is very interesting because usually when you have trainees, you just think that they're not as useful as real employees, if I may say. So it's tempting to have them working from home. But on the other side, and on the IT security side, when you have trainees, you don't have professional devices to provide them with. Especially working from home. So usually trainees are sent back home because you need the facilities. You need the facilities for social distancing, for example. And so you're saying, okay, I would like to take trainees, but the trainee has to work from home. And so some breach of security can come from that kind of behavior, because a trainee is not an experienced person if he or she doesn't have an adequate, appropriate devices to work from home. It might lead to a very unstable and insecure situation. And so the question we have to ask also all the time is what adjustments should be made regarding GDPR compliance and data security. First of all, and it is the same as in label, as Delphine was saying, is to differentiate categories. First thing first, you have to reopen up your records of processing activities and reassess your privacy impact policies. Meaning that, for example, if you implemented PIA for your usual working place, working environment, then you have to reassess it from a remote working perspective, because it is very different. First, because you're not in the secure facility of your employer, and also because you don't have the same tools and you have different person in your environment, because usually when you go to work, you don't have your spouse and children or even pets around you working with you. Working from home, you have all that, and you can have the door that is ringing at some point. You may have to go to the grocery store or anything like that. And this is the kind of stuff that is still common sense, but you have to evaluate these risks from the employer perspective to be accurate and to be sure that your GDPR and IT policies are applicable for remote working. So in the same aspect, you have to adapt and even provide new policies or new processes, such as encryption. Because, for example, you have a lot of companies that have encryption on site, but that didn't really think about that for workers working from home. So you have to provide them with a tool that is able to encrypt in the same level of security for remote workers. And for the other, we also talk about data governance policies, training of employees, and specific attention on sensitive data and on the legal basis for GDPR processing. Because also something that was very tempting during the lockdown and during remote control periods is to provide third party with data that they were not usually in charge of. And so all companies have to be very careful about that, because if it's new purpose, new processing, or new third party, you need to have a new legal base. And so, for example, if you process your data based on consent and that you have a new third party sharing, then you have to re-ask for consent or rethink your processing of those kind of data, whether data, just personal data, or sensitive data, and more accurately for specific sensitive data.
Do I have to compensate for the professional use of the remote worker's home? This is the question of the costs incurred and also the occupancy allowance. So yes, preferably if the remote working request comes from the employer, and no, if in the remote work request comes from the employee. But bear in mind that the ordinance of September 2017 removed from the labor code the employer's obligation to cover costs directly related to remote working. Please also bear in mind that the case law considers that the employee may claim an indemnity for the occupation of his home for professional purpose as soon as a business premises is not effectively placed at its disposal. Clearly, it's the situation where you have sales, you have a foreign company who doesn't have premises in France, but hires salesmen in the four corners of the France to sell its product. In this situation, we consider that the employee are home office workers and then needs to have an allowance for the back office that they perform from their home. Does the employer have to pay professional expenses of remote working, such as lunch vouchers, public transportation pass? I have explained that before. It's a complete nonsense that the Labour Ministry and the URSAF explain that it is mandatory, but if we comply with this instruction, it means that we have, as an employer, the disadvantages of all, meaning that you will have to pay lunch vouchers, public transportation pass, maybe an occupancy allowance, maybe the cost incurred by the remote working. So it's a complete nonsense. This is why I really encourage my clients not to comply with this instruction, which, by the way, is not binding. Is the employer still bound by a safety obligation in a remote work situation? Yes. And I think that in the remote work situation, it's more the psychological side and the isolation risk, which is at stake. And this is why managerial practice must be adapted. How can the principle of inviolability of the home be reconciled with the prevention of professional risks for remote worker? Again, Article 8 of the INA of 2005 compromises with the consecration of the right of access to the employee's home by the employer, subject to the employee's agreement. It's not ideal, but it's the only way to find a good balance between the inviolability of the employee's home as well with the prevention of professional risk. Regarding this point, I just point out that in the INA of 2005, there is an obligation for the employer to check the compliance of the electricity in the employee's home. So it's something that employers should know.
Also, again, on sensitive data, I won't be long on that aspect, but just keep in mind that in France, you have additional legal bases that exist in addition to the general GDPR provisions. And so, for example, and this was also the main interest of this presentation, is one of the legal bases added by the French government is the employment-related obligations that, of course, Delphine mentioned several times. And so, just in the dealing with the COVID crisis, the employer is allowed to record the date and identity of the data subjects suspected of exposure and the organizational measures taken, but is supposed to communicate the information to health authorities upon request. And this aspect is based, obviously, on this addition on employment-related obligations that was added by the French government.
And last but not least, the last question, feedback that we wanted to talk about is how to control the activity of employees in remote working. We believe that this question and its answer is really the best way to liaise our both expertise. It is clear that social distancing and remote working does not erase the possibility for the employer to control and monitor the working time, to control the activity of the employee, but it is very difficult to find a good balance And I think that if we step back, the confidence and the autonomy of the employee are really key to have remote working efficient and satisfactory for the employer. So yes, probably the sustainable remote working will be going with keyloggers or timesheets to check whether the right to disconnect and the workload of the employee is consistent and is satisfactory and will prevent the company from claims regarding overtime and overloaded work. But clearly, the issues on that are very important on a data protection point of view.
And so the question that we have to ask also is, can the employer use technology tools to impose activity monitoring? And the answer is yes, but be careful. The means used must respect proportionality principles of data processing and privacy rights of the employees. So as Delphine mentioned earlier, the social fracture is very important to take into consideration in monitoring activity of an employee. We already talked about the fact that you're not supposed to monitor every single act of your employees. So you cannot impose share screen, for example, or keyloggers at all time. In the same manner, you're not supposed to impose camera during all working hours, but you cannot impose to your employees to have their camera on even for one video conference or for one team conference or team meeting via any Zoom or anything like that, based on the privacy rights and also based on the social fracture. Because obviously when you are in a manager position, you don't have the same way of life, you're the same interior, the same flat or house than a worker or an employee, depending also on the location, whether you're living in Paris or in Aix-en-Provence, you don't have the same constraints. So obviously you cannot impose everything that might be a problem for the employee. On the other hand, you can put in place activity reports or achievement of goals. So it's easier to check whether or not the employees has done its own tasks, but without imposing anything too much invasive from the employee's point of view. And also you can use time entry software or collaborative tools with individual tasks. So these are the do's and don'ts of technology tools to monitor activity of your employees working from home.
And probably the best way to monitor the working time of your employee is probably a combination of several forms, such as a self-declarative system where the employee shows like a timesheets, the days and where he worked and where he has rest days, a periodic follow-up interviews, a remote working overload alert system, activity reports, activity monitoring software. But you have to understand that in every company where you have social economic committees, you cannot implement such monitoring system without consulting them. And it's the same if you decide to implement an automated control system. And just as Pauline said, in any case, this monitoring system should be justified and proportionate to the business and the liability, the responsibilities of each employee. So unless you have some questions, I would like to thank you for your time and your attendance to this webinar. I will be very happy to answer any question you may have on labor and employment law aspects of remote working after this conference. On the last slide, you have our contact details with Pauline, and we will be more than happy to answer all your questions.
Thank you very much for your time. We don't see any question. We're running kind of a little late, but thank you for attending and staying until the end. We hope that it provided you with some insights, and we will, of course, send the presentation to each and every one of you, so you can refer to those examples and everything. Do not hesitate to contact us if you need, and we wish you a very pleasant day.
Bye.